Madam, you're mute.
Yes, sir. On behalf of Ministry of Education's Innovation Cell, I am Selvarani, Innovation Officer. Glad to welcome today's speaker, Professor Prabuddha Ganguli, and the faculty and student members from IIC institutes who joined online for the fourth session of IP Talk Series. IP Talk Series is organized for the IIC institutions in collaboration with Indian Patent Office to celebrate the World Intellectual Property Day. This IP lecture series consists of 4 sessions and conducted from 27th to 29th April for the IIC institutions. The first session was on translating ideas to inventions by Professor Unnat Pandit. Second session was on best practices for documentation of research and conducting preliminary assessment of patentability by Dr. Malati Lakshmi Kumaran. Third session was on important aspects to consider while preparing patent specification by Dr. Dinesh Patel. In this series, the next session is on assessing worthiness of inventions and creating strategies for patenting them outside India, and the expert speaker is Professor Prabuddha Ganguli. It is my privilege to introduce the speaker of the today's session. Professor Prabuddha Ganguli, CEO Vision IPR. He is one of the very early starters three decades ago in IPR in India, with a unique blend of excellence in academics, R&D, industrial experience of several decades, and international involvement as consultant to the World Intellectual Property Organization WIPO. He initiated the process of integrating IPR in the formal education system through his trademark theme IPR Internalize in several academic institutions in India and abroad. He was also honorary scientific consultant to the principal scientific advisor to Government of India from 2003 to 2017. He held the MHRD IPR chair in Tezpur University, Assam from 2012 to 2017 and was visiting professor at the Rajiv Gandhi School of Intellectual Property Rights, IIT Kharagpur from 2017 to 2020. In addition to his consulting assignment in Vision IPR, he is also honorary professor at the Homi Bhabha National Institute, Department of Atomic Energy, Government of India, advisor and adjunct faculty in IIT Jodhpur, emeritus professor at the Vishwakarma University, Pune, honorary visiting professor in Jawaharlal Nehru University, New Delhi, and co-principal investigator in National Digital Library of India, NDLI, IIT Kharagpur. He is an elected fellow of Maharashtra Academy of Sciences and was honored with the Lifetime Achievement Award in 2014 by the legal fraternity in India under the banner of Legal Era. He has published over 50 research papers in technical fields and is the author of 6 books and over 60 publications in IPR. Thank you for joining with us, sir. Before handing over the session to sir, I request all the viewers to post your questions in the comment section. We will take the questions at the end of the session. Now the session is over to you, sir. Thank you.
Thank you very much. I would like to first share the screen so that we are able to, yeah. Is the screen being shared?
Yes, sir, it's being shared. Yes.
Is it okay now?
Yes.
And is my voice okay?
Yes, sir. Perfect.
Good. Excellent. Good afternoon to all of you. It's very interesting that I'm delivering this particular lecture at the moment from the US. It's 5:30 in the morning here and 3 o'clock, just past 3 o'clock in India. And what the topic for today is assessing worthiness of inventions and creating strategies for patenting them outside India. And you've already attended 3 lectures in the last 2 days. This is the 4th lecture in the series. And what we will do is I will straight away go to the starting point. And that is that as researchers, as students, as faculty, as academicians, and also possibly as entrepreneurs, we may have lots of innovations. Mark the word innovation. The question is, you've already gone through a process of hearing from the three very eminent speakers what is the best way to protect an innovation that you have. Question that comes in, how do I make it my intellectual property? It's a creation of my mind, but how do I convert it into my property? And more important, how do I convert that property into an asset? So the question that comes in, should I just go and disclose it to the world? Or should I first protect it and then disclose it to the world? That's the first question. I think this question has been answered already by Professor Unnat Pandit, also by Malti Lakshmi Kumar, and by Dr. Dinesh Patil. Question that comes now is, should I get it protected in other countries in addition to protect it in India? And if I do it, then the question is, how do I benefit from this activity? So it's a big question in front of me as a researcher, as a student, as a faculty, as an entrepreneur, that I have this innovation in front of me. Question is, do I only keep it as a protected property in India, or do I protect it across the world? Why do I need to protect it across the world? Is the question that I'm asking myself. So therefore, I need to go to some basics, and those basics have already been done, but I will just repeat it just for the sake of a quick recollection. And you've already understood in the last three lectures that the patent is a grant. This grant is given by whom? By sovereign or state. That means this state is not state of Maharashtra, not state of Rajasthan. It is state means India, the country. So it's a sovereign or state, independent country. Given this right is given to whom? It is given to a person. What sort of right is it? It's an exclusive right. Interestingly, what you must have already heard from the earlier three speakers, that this right, exclusive right, is a negative right. What do we mean by negative right? It is to stop others from making, using, selling, offering for sale. What? An invention. So now I've changed the word from innovation to invention, right? So it's an invention. How long do you get the protection? It's for a limited period. The question that comes in, what do? You can stop somebody making, using, selling, offering, or offering for sale your patented invention without your consent. So somebody must take your consent, must take your permission to do all these activities. Then what Dr. Dinesh Patil has already talked to you is that you have to do it in exchange for disclosing it in a patent specification. So Dr. Dinesh Patil explained to you all the good practices of how to write a good patent specification. You have to write it in such a way, and Dr. Patil has already covered that, such that a person skilled in the art can reproduce the invention. So that is where the patent specification comes in. You file this particular patent specification in the Indian Patent Office, for example, and then the process of patenting starts after you have filed it in the Indian Patent Office. Now, important part for us to understand and recognize that all intellectual property, be it patent, be it copyright, be it in design registration, etc., all these things that we are talking about, this is about knowledge ownership. So which means that if you are given a grant, you own that knowledge. If you have been given a patent, granted a patent for your invention, then you own that invention. You are the owner of that invention. You get some rights for it. Do you get that rights forever? No, it's a limited time. And do you get this right? Where do you get this right? It is territorial. Very important for us. Territorial. So when we are talking about territorial, it means your right is restricted to the country in which it has been granted. There are certain exceptions and obligations. I will not touch that at this point in time. Important for us to understand that this particular right which is given to you is territorial in nature. So the question that comes in front of us is, one patent application in India, I can always ask myself, is one patent application in India not sufficient to give me protection in all countries? Then the question that comes in, if I have to file patents in various countries around the world, how do I plan for it? what is the process of doing this filing and getting the protection across the world? And what is the cost? Very important for us. We need to check on all these points and ask these questions and find the answers to it. And I'm going to answer these questions as I go along today. Similarly, there's one more important part that we need to recognize and understand. Understand. The grant of a patent is by the state or sovereign. This patent right is valid only in the country, within the political boundaries of that particular country in which it has been granted. So which means if I file a patent in India, then my rights are restricted to India only. My patent right is restricted to India only. I can only stop others from making, using, selling, or vending the invention only in India with a patent that's been granted to me in India. Can I stop somebody in Bangladesh? Can I stop somebody in Nepal? Can I stop somebody in Sri Lanka? Answer is no. Because my rights have not been given by that government. The right was given to me by Government of India, by the Indian Patent Office. And therefore, my right is restricted only within the political boundaries of India. And there is no concept of international patent. And because there is no concept of an international patent, it is incumbent on me that if I am seeking protection in Bangladesh, if I'm seeking protection in Pakistan, if I'm seeking protection in Nepal or Bhutan or any other country like US or wherever, then I will have to file that particular patent in that country, and I have to get the rights in that country as per the patent law in that country. So which means that simply filing a patent in India only, I do not get my rights across the world, because there is nothing called an international patent. Therefore, the question that comes in, that how do I go about doing this? And the first part, the question that we should ask ourselves, why do I need to protect it in other countries? Is it not enough? Or because I'm doing my business in India, or I'm going to, commercialize it in India, then does it make any sense for me to go and file this particular patent in other parts of the world? I need to ask that question. I need to answer that question. And that's precisely what I'm going to do. Now, so therefore, when we go to the next part, before we go into all this, we have to appreciate that there are what are known as international agreements and conventions in which countries come together and they agree among themselves that, okay, we agree as a group of nations, right, under certain conventions or agreements, that we will, go about respecting each other's rights in a certain manner, or give the rights in a certain manner. And therefore, there are several agreements related to patents. There are agreements for copyright, there are agreements for design registrations, and other forms of intellectual property rights. But since we are talking about patents today, we are talking about, a certain set of conventions or agreements. One of them is where some set of countries come together and create what is known as a convention among themselves. And they agree among themselves, okay, we will agree to do the following things together, and we will respect it because we have agreed it together. So those are called convention countries. Now, there is one convention called the Paris Convention. And in this Paris Convention, so many countries came together. Today, there are 179 countries, as I speak today, who are members of the Paris Convention. Right? We will talk about what the Paris Convention does in a minute or two. Then there is this organization, a UN organization called the World Intellectual Property Organization, WIPO, which is located in Geneva, in Switzerland. So they run a program, or they run a system, a convention called Patent Cooperation Treaty. In short, it's called PCT. And this organization, mind you, cannot grant patent, right? Why it can't grant patent? Because it's not a country. It's not a government. It's a governmental agency, intergovernmental agency. So they can create a system, a platform where they can facilitate people to file patents out there. That's what it does. So the PCT system, what is there, does not grant patent, but helps you to file patents across the world. Now, so when you look at something like this, what does it do? And I will go into fair amount of detail on PCT after a few minutes. Similarly, there is one more convention, and that convention is called the Budapest Treaty. What does the Budapest Treaty do? It says if you're dealing with microorganisms, then we said that people who are skilled in the art should be able to reproduce your invention. So if I'm using a microorganism for my patent, and if somebody wants to repeat that, how will they do it? From where will they get that microorganism? So this particular, called Budapest Treaty says that you must go and deposit that microorganism which you have disclosed in your patent specification, put it in a certain depository, an international depository, so that anyone who wants that microorganism can go to the depository and ask for it to work on that particular microorganism. Similarly, there's what is known as the International Patent Classification under what is known as the Strasbourg Agreement, and one which you have already heard, which is
Sir, can you hear me?
governed by, yeah, which is
We are not able to
governed.
hear you.
You're not able to hear me? Oh God, what happened? What
Yes,
happened?
we can hear you.
You can hear? Fine.
Yeah.
So, okay. So
I can
there is
also
what
hear
is
you,
known
sir.
as the TRIPS Agreement, which is called Trade-Related Intellectual Property Rights, which is governed by the World Trade Organization. And as we speak today, under that particular thing, what the World Trade Organization, what the TRIPS Agreement does, it sets the minimum standards for members of WTO to follow while framing the national laws. India is a member of all these conventions which I've listed here. So under those
Dinesh
conventions
sir,
and
can you hear
agreements,
Prabuddha sir's voice?
can you hear me?
I can hear. I'm hearing him. I think so. There is some problem at your end. We are able to hear Dr. Ganguli.
Okay, should I continue?
Yes, sir. You continue because
Okay, so I'll
I'm able to
continue.
hear you.
Fair enough. So let me continue. So all this list of agreements or conventions which are there, all these in which India is also a member. Therefore, as a filer of patent in India, I can take advantage of all these conventions to go and file my patents across the world out there. Right? Now comes in, I will go into only two of the agreements out here, what is known as the Paris Convention and the PCT, and ask ourselves a few questions as we go along. And then we will go into the strategy part of it. So when we look at this, when we work it, so the question that comes, as I said, why should I file my patent in other countries? And what are those considerations that I should keep in mind while taking a decision that should I file this particular patent application only in India or should I go in other countries as well? And one of the first questions that comes about is which are those countries where my invention has a market or can be sold? So that's the first question. Because why should I file it in other countries if my product or process which I have developed, if that does not have a market in that country, then why file a patent? Why unnecessarily spend the money? So I need to ask a question. So therefore, when I have an invention, I need to first find out where all in which parts of the world my invention has a market. So it's very significant and important to first establish that so that I then decide whether I'm going to buy, whether I'm going to protect it in that country or not. Next question, which are the countries where the invented product may be manufactured? So which means why? Because that means I will have competitors in those countries who may manufacture my product. So how do I stop them? I want them to take my permission if they want to manufacture. So I must identify those countries in which my product may get manufactured. So I may like to protect it there by filing a patent in that particular country and then stopping others from making, using, selling, or vending my invention without my consent. Very important. So that's a point number 2. Let's come to a point number 3. Which are those countries where the invented process may be used? I may not have a product patent, but I may have filed a process patent for a process. So I must find out those countries where my process can be used. So I must go and protect it in those countries. So I must do that research for myself. So only doing the scientific research or technical research is not good enough. I have to work my business strategies on that. Similarly, next question. Not all, I'm sure Dr. Pandit, and also Dinesh Patil and Malti would have talked to you that not all types of inventions can be patented in all countries. Certain types of inventions are not allowed to be patented in certain type of countries, certain countries. Therefore, you need to evaluate, you need to assess, make an assessment. I have invented, I've created a new microorganism. Can I file that patent in that particular country of interest? And will they give me a patent for that? Or are there any restrictions in patentability of that? I need to establish that. Similarly, I may have developed a new method of doing surgery. Now, whether that new method of doing surgery is patentable or not in a certain country, there is no point in my filing a patent if the country does not give a patent for methods of surgery on human body. So I need to find that out. Therefore, I must go and read the patent law or find out from an expert. Well, this is what my invention is. Do you think, even though it has market in some other country, will it get patented there? Need to ask that question. So that is another question that needs to be assessed in the series of parameters that I have to assess. Similarly, the question comes in, that are there companies or organizations or governments where they may be interested in taking permission from me, license, or even purchasing the patent from me? And so that would be another point. I need to assess that here is my invention. What is the depth of my invention? What is my invention? And whether the countries in which I want to go and file a patent, whether it is of any interest or relevance in that particular country. So these are the first set of questions that I need to answer. There's a second set of questions I need to answer. Let's go to the second set of questions as we go along. That is, we continue on this journey of asking questions for hours. So we have to assess. So which are the countries where the patent can be effectively enforced? That means I file the patent, I get a patent. Somebody copies me there without taking my permission. What can I do? Can I go to the court there? Can I fight a case? Will I win? So the laws of that particular country are going to be very important to find out whether I can effectively enforce my patent. So simply filing patent, okay, fine, you have a patent. So what? So I have to ask these questions. I have to assess the relevance and whether my patent can be enforced in that country or it cannot be. Now, which are the countries where there are matured patent markets? Nowadays, can you believe it? Like we buy and sell fish, like we buy and sell vegetables, like we buy and sell fruits. Today, interestingly, there are patent markets. So there could be certain countries where the patent markets are very mature. Now, if I file my patent in those countries, for a patent application, I get my patent in those countries, then I can enter the patent market. So I don't have to manufacture there. I go to the patent market, maybe I sell my patent. And I get the money that I invested. I get the benefit of my, mental creation, the creation of my mind. Very important. Similarly, there are various countries today various organizations today where, you can take the patent, go to the bank, go to a financial institution and say, here is my patent. The value of this patent is so much. Please keep the patent with you. It's like, securitization. Securitize. You give the patent to that particular financial institution, hold it, give me so much money on loan, right? So question comes in, can I use my patent because it's an asset? There's a value to the patent. So if I've done good work, if I've evaluated that particular bit, if I've seen that, my patent now is of a certain value, then I can go to a financial institution, I can go to a bank, I can go to such places and say, hold it. जैसे gold, दोनों को हम गिरवी रखते हैं, ऐसे patent को भी हम गिरवी रख सकते हैं. We can keep it out there and then take a loan against that. And when I pay the loan back, I say, okay, take the patent back. Very important. When we buy house, we take loan. What do? We mortgage that particular house to the bank or the financial institution. Exactly, you can do that with patent. So we need to look at all those aspects. Then also, very important, I may have strategic collaborators in certain countries, and I have to identify that. And I can find out which are those countries where one can find strategic collaborators. But if I have to get strategic collaborators, I must first protect my invention in those countries and then seek collaborations. So there are a large number of such parameters, So, which are important for us to not only recognize but also to act. So these are some of the parameters that we need to assess. Now, if we do all this, which means that before I file or decide file my patent in other parts of the world, right? I have to do a lot of homework. It's not just go blindly and go and file, because it costs a lot of money to file. It costs a lot of money to get the patents. Just simply filing does not give you a patent. The moment I file a patent application in the Indian Patent Office, Dr. Dinesh Patil's team goes into it, makes an assessment, does an examination, then tells, and look, these are the reasons why you may not get a patent. Then you have to justify. You have to then go for the examination. You then have to go for a hearing. All these cost money and time. So before investing on all this, you therefore must take a quick call and assess, is it worth really filing this particular thing into? And will I get the money back, whatever I'm investing? And I make a strategy out there so that in the long term, I benefit from that. So these are some of the strategic thinking when you say, I will file the patent abroad or I will not file the patent. Just very quickly now, I will run through some of the international conventions under which you can file this particular patent abroad, and then what are the ways in which you get a patent abroad. And then we will take a few case studies as I go along, okay? So taking this cue from here, let's take the Paris Convention. What is the Paris Convention? India is a member of the Paris Convention. Very simple. Don't go into too much of the law. You have to just simply remember some of the principles that are there. So what does the Paris Convention say? Very simple. That within all these countries, they have agreed that if you have filed your patent for the first time in any one of these member countries, that day on when you file the patent in one of the countries for the first time, right? That's called the priority date. It's the date of birth of the patent, DOB. Now, that's called the priority date, which then the Paris Convention in very simple terms says that if you file that particular patent, let us say on 29th of April 2022 in India, and that was the first filing that you did in India, that's the priority date. Starting from there, within 12 months, you are expected to go and file the patent in other Paris Convention countries. So even after filing the patent application in India, after the priority date, if you have gone and say sold that particular item in India, or you have made a presentation in a conference in India, it has gone to the public. Now, within 12 months, you're allowed to go to any of the Paris Convention countries and file that. And when you file that particular patent within patent application within 12 months of the priority date in India, those countries will respect that priority date. And by respecting the priority date, what do I mean? That even though I went to public after filing the patent application in India, that those Paris Convention countries will take as if I had filed it in those countries on that particular priority date. So they will respect those things, and therefore what is known, which Dr. Patil and Malti Lakshmi Kumar must have mentioned to you, that this concept of novelty, I don't lose my novelty because my priority date is respected for 12 months. So that within 12 months, I can go to any of the Paris Convention countries and file my patent application. That is what the Paris Convention says, which means that I can do that in all the 179 countries that are members of the Paris Convention. But important part of it is that I must do it within 12 months. So what happens if I can't file that patent application within 12 months in other countries? Then is it that I can't go and file the patent application anywhere else in the world within those afterwards? That question is answered by what is known as the PCT, the Patent Cooperation Treaty. Now, what does the Patent Cooperation Treaty do? It says very simple again. Let's not go too much into the law part of it, but let's understand the principles. What does it say? That if you have filed a patent application for the first time, example, in India, let us say on 29th of April 2022, then what the PCT convention says, of which India is a member, what the PCT convention says, that within 12 months of this priority date, 12 months, like in Paris Convention, then PCT says you don't have to go to the various countries and file your patent application. File one patent application under the Patent Cooperation Treaty within 12 months. And if you do that, then the window when Paris Convention, which was only 12 months from the priority date, opens up to 30 or 31 months, so which means that you are no more restricted to file your patent across the world only in 12 months. You can actually, if you file a PCT application after filing your patent in India, you can actually file your patent application in other parts of the world after 30 or 31 months. So you get more time to think and answer all those questions which we raised before. So you then take your time, sit down after filing the PCT application and think about all those questions that you need to answer. So that is to evaluate the patentability in countries of interest, shortlist the countries and the regions, and then you file a PCT application within 12 months of the priority date. Very important that you need to think about all these. And for all this, mind you, you don't, as researcher, a student or faculty, you don't have to go into the nitty-gritty details of this. You have to only appreciate after this lecture that you have such options. And we have the professionals who can help you. Not only that, the Indian Patent Office itself has a certain guidance. It has got, certain guidance it can give you, and we can help you to really overcome all these, how to do, what to do, where to do, and what not to do. So the question is that you need to be aware that this is the potential. This is what we need to do, and this is what I need to think about. Very quickly, just to tell you that if I have to file a PCT application, I don't have to go to Geneva. I can file it even in the Indian Patent Office, right? Because the Indian Patent Office is recognized, for PCT as well. So there's a separate department in the Indian Patent Office which does that. just to cut a long story short, to file a patent application, PCT application, it's roughly about 1.23 lakh rupees for one application, right? Plus, there's a certain amount of things you may need, about 13,008. So roughly, give or take, about 1.5 lakh rupees that will be required to file a PCT application out there. That is the thing. Now, just quickly, what I will say. So, what do you get out of this? I filed the PCT application. So here, 0 priority date. That means application filed in the patent office, which was the priority date. And within 12 months, I filed the PCT application. The moment I file the PCT application within 12 months, you can see I get 30 or 31 months, completely from here to here to file my patent applications in other parts of the world. So, but what do I get by filing a PCT application? How does it help me? And how does it help? Because what happens is within 4 months of applying for the PCT application, they give you, the PCT office gives you, something like an assessment of your patent application. Whether it will be, what is the likelihood that it will get patented? What is the likelihood that there is enough, literature which will probably destroys the novelty of your invention? Or what is the literature that may possibly destroy the inventive step? So it gives you a report. It's like a scorecard. And now you can assess using that scorecard what you want to do. So just to take you further through that. So here, suppose I filed the, a patent application in India, then within 12 months out there, I can file a PCT application. The moment I file that, I get the 30 or 31 months window opening up. I'm not restricted to 12 months only to go and file my patent application in other parts of the world. Now, see the other part, very important part, what the PCT helps you. That, when you go and file, for example, a patent application in China, or you file a patent application in Japan, you file a patent application in Korea, then you to get your patent specification, which Dr. Patil told you, you have to translate that in their language. Now, you can't translate it. There's an official translation. And that costs a lot of money. So if you are clear in your assessment that I must file it in Korea, and there are good reasons for me to file it in Korea, then I will get the translation done. But by filing a PCT application, at least my priority is protected. And then I can take those 30 months to get all those translations and everything done. And then assess whether I will pay those fees or I will not pay the fees. It will depend how important my patent is going to be in Korea or Japan or wherever it is. That's the first part. So, when I get the PCT report, I can then do a quick assessment out there. So what does that do? The PCT report tells me what are the technical areas that were searched by them. They do a patent search. And having done a patent search, they tell us, oh, in this particular application, you may have more than one invention. Therefore, you may have to file more applications because one patent is given only for one invention. So that's the first part. That's called unity of invention. I won't go into details. It gives you a list of all the relevant literature, saying these are all the literature which is there. That have you taken into consideration this? And if you haven't, then these are the reasons you may not get a patent, because this is the literature that tells you. Actually, before filing the patent application, you should have done the full search. But PCT also does a search and gives you a search report, helps you. Right? And then it tells you from here, also, it gives you a very classified report, tells you how those particular, publications, what is the value of what is the nature of those publications, how, close those publications are to the invention that you have done. And so taking into consideration all this, it gives you a preliminary opinion on novelty, inventive step, and industrial applicability, which means that from the PCT report, you can do a further assessment of an invention. Would you now like to go and file this in other parts of the world or not? And if you think you shouldn't, then you will take a decision, I will not file this in other parts of the world, right? So you go through all that assessment. Mind you, patent filing, just simply filing a patent does not end. Filing a patent is only the beginning of the process. It's like the child is born. And only, just after the birth of the child, it has to grow, it has to be nurtured, it has to be taken care of. Only then it will become a man worthy of helping the society. That's how a patent application should be looked at out there. Now, what I will do is, I will now, I've already explained to you all this. I will just take two simple case studies before I end. And here is the case study which I'm giving you of what is known as this company. It's called 4W, Image. It's a small company. What is the history of this company? That they have looked at market opportunity. You see these huge, big hoardings, and also, advertisements on the walls and other places. Now, what this company did was very simple. It studied, all these products. And having studied these products, it says, look, how do conventional image transfer technology is done on walls, on big hoardings, etc., etc. And they realized very, very interestingly, they realized that when these big, the present day means when they were getting into the system, they said, look, what these people do is they have to put the product on the substrate, on the wall, and then they have to use a hot gun, to transfer the image onto the substrate. They said, oh, that's so difficult. Can I find a simpler method of doing it? This is what this small group of inventors thought about. And mind you, this is actually a startup under the startup scheme of the government of India. This small group. I've worked very closely with them, so I'm giving you this example. So what they said is, instead of using a hot gun and heat to transfer the image onto the surface, can I simply use water at room temperature? In which case I can only use a sponge and transfer the image permanently onto the substrate. Beautiful thinking. I don't need equipment, I don't need heat, I don't need anything. See the fantastic thinking of this young Indian entrepreneur. So they looked at it. So what did they do? So they then did extensive literature search. They did a complete landscaping of patents. We helped them out. How to do the landscaping. We looked at all the literature and then found, oh, what you're saying in terms of a thought process is not there anywhere in the world. So can they create a product of that type? So they did it. And having done it, what did we do? We first filed a patent application in India. Then what did we do? We filed a particular patent application, we filed a PCT within 12 months of filing the patent application in India. And then, before I go into that, see, you can see this part. Here, everything is being done to transfer. The image is being done with a hot gun. Here, the transfer of image is done with water. How fantastic. Now imagine the potential of something like this, huge. So you can see that what they did was scan image. They registered, see, we filed the trademark for them. We filed the patent application in India for them. And under the startup scheme of the government of India, they got the patent very quickly in India. And we simultaneously filed the patent in other parts of the world and through the PCT route. And then they got patent in USA, Japan, China, Australia, New Zealand, South Korea, Macau, and other countries. Now, what is the advantage of this? Now you can see, having filed these patents in other parts of the world, having assessed the relevance of these, today, this company, Can Image Media Tech, this company today is negotiating deals in different parts of the world for this technology and this product. Now imagine a small startup in India which filed a patent application in India, then went through the PCT route, doing all these serious assessments that we talked about. A is a leader in this particular field, a startup, mind you. And this is what Government of India has done. Government of India has created a facilitating platform for young entrepreneurs to come forth and do these. So I would urge you people to think about all these things and really find out the appropriate people who can help you out to really take these things further. So you can see this. The technology is so good. See the quality of image right on a wall, which is, completely uneven. Otherwise, using the normal technology, you would have to, do very sophisticated and very expensive. And here they have come out with technologies of this type, which is done so simply and easily. So this is example number one. And my last example, which I want to give you in today's talk, after which we can have questions and answers, is, for example, that was of a small entrepreneur. Here is a company, a drug company in India. What did it do? Again, to create the strategy. What is the strategy? It first selected certain drug substances. They did a search, found out that for these drug substances and for the formulations of that, there are patents which are expiring or is going to nearly expire in certain selected countries. So patent search became important. Then, having created a patent landscape, they said, okay, these particular patents belong to some very big companies, and those patents are about to expire. So these big companies would like to extend the brand. So they're looking for formulation. They're also working on it. So what did this company do? This company then designed formulations which are non-infringing and patent. They created a patent strategy for those formulations, filed patents in India, then filed PCT application, and then in the national phase, as I said, after 31 months, filed these particular patent applications in various countries of business interests around the world. Got regulatory clearances, and then negotiated deals with various companies simply to sell their patents off. And they sold those patents off in a very strategic manner. In fact, I was involved in all those transactions out there. So once they sold those patents, they even went and said, okay, we have sold you the patents. What about the know-how? Are you interested in the know-how? So they sold the know-how, they sold the patent. And then after that, this foreign company told these people, can you manufacture it for us? So they gave them the license back. So you can see the strategy that's created. And all this was possible only because, as I told you, that when you go into the, now, for example, why was it possible? It was only possible because the right questions were asked right in the beginning, and a complete framework of questions and answers which were put, a strategy was created for the foreign filings, and we knew exactly why we want to do certain things. So I will stop at this stage and leave the floor open for questions. Please go ahead.
We have very few questions. I'll just read it out.
Yeah, please. Yeah, please go ahead.
Yes, sir. The question is, can innovator protect his or her innovation in a foreign country by only filing domestic patent? Can other innovator patent it in those countries where it is not patented?
Well, very good question. First part is, as I told you, there is nothing called an international patent. Therefore, if I want the protection in other countries, I will have to file the patent application in those countries. Right? So I do not get, by only filing it in the domestic, I don't get protection in the other countries. So that's the first part. That's the answer to the first part of the question. Come to the second part of the question. The second part of the question is that whether somebody else can protect it in other country. The answer is no. Because if my patent application has been filed here and if it has been published, then it becomes a part of the prior art. It becomes a part of the public domain knowledge. In which case, I stop that person from filing the patent in the other country and getting protection in the other country. So this is called as defensive, defensive publication. You file it here and then publish it. It goes into the public domain. You stop others from filing it. So again, that's another consideration that you do. And thank you for asking this question. It's a very, very good question.
The next question, what are the major difference between the patent laws in India and US?
Okay. Now, if you take the difference in the patent laws in India and patent laws in US, first part is because both US and India are members of the World Trade Organization, and both are signatories to the TRIPS agreement. The minimum standards are the same, okay, in both, minimum standards, because there's harmonization. But is the patent law same in India and the patent law same in the US? No, it's not. Now, so therefore, if you come to the patent law in US and patent law in India, there are certain elements which by the TRIPS agreement is called that patentable subject matter. When you come to patentable subject matter, there are certain types of patents that you can't get a patent in India. Why? Because the Indian law says so. And it is compliant with the TRIPS agreement. Whereas the US law says, no, for those you can get a patent. For example, in India, when I do when I file for what is known as a method of treatment, how do I treat a disease on a human or on an animal? The Indian patent law under Section 3 says you can't get a patent for that. Why? As per law, that it is not considered to be an invention. Whereas the US law does not consider it that way. So for a method of treatment, you can get a patent in US, but you won't get a patent in India. Like this, there are other considerations, in different countries. So when you want to file, that is the reason, if you remember in one of my slides, it said that when you have an invention, you have to assess whether according to the law in that country, whether you will be able to protect it or you will not be able to protect it. So that's a consideration that you have to take into. By understanding what are these differences and nuances in the different countries. Please go ahead.
Sir. Thank you, sir. So we have received only these two questions. And thank you very much, sir. And sir has emphasized rights are territorial. There is no concept of international patent. And also he has elaborated why do we need to protect in other countries. And the assessment parameters to identify the countries to file patent with the case studies. Thank you very much, sir, for the wonderful and the insightful session. We are very grateful for having had the opportunity to organize this IP lecture series in collaboration with Indian Patent Office for the IAC institutions under the celebration activity. I thank Indian Patent Office, especially Professor Unnat Pandit sir, Controller General of Patents, Designs and Trademark, and Dr. Dinesh Patel, Deputy Controller of Patents and Designs, for their continuous support for organizing this IP talk series. I hope Ministry of Education's Innovation Cell and Indian Patent Office will continue to organize this kind of sessions to strengthen the IP ecosystem in educational institutes, to create a culture of systematically protecting new ideas, research, and innovation having national and global relevance. Thank you, sir. Thank you for the wonderful opportunity. Thank you.
Thank you. Bye-bye. Have a good day.